Okay, I'll go ahead and call to order this hearing of July 24th, 2024 in matter of case file Z0161-24, application for a conditional use permit for Curran Road Reservoir. I think the city has a different name for it. High level reservoir number 5. My name is Joe Turner. I'm the county's hearings officer. I'll start with some brief announcements and a summary of the process that will follow, so everyone understands how you can participate in the hearing. I start by saying I'm not a county employee. I am licensed as an attorney and trained as a planner. I serve under contract to this Board of Commissioners. I say that so you know you're getting a somewhat independent review of the application before me today. My role as the hearings officer is to conduct public hearings and make decisions about certain land use matters in this in Clackamas County. So I was in a different jurisdiction yesterday, and I need to switch where I am. In making those decisions, I have to apply the county's existing laws. I am not a policymaker. I don't have the authority to vary from or change the laws. If you think that the laws need to be changed, you can work with Board of County Commissioners and Planning Commission to do that. But state law requires that this application be judged based on the laws in effect when the application was filed. As a hearings officer, I'm to provide an unbiased decision maker. I believe I am unbiased with regard to the application before me today. I have not had any pre-hearing contact with any of the parties regarding the substance of the application, and I don't have any interest in the subject property or any of the surrounding properties. However, anybody has the right to challenge my impartiality, to argue that I'm biased in one way or another, and you can do that when it's your opportunity to testify. Procedure will follow. I'll start by asking staff to summarize their staff report, copies of which are available on the county's website. Then the applicant will have an opportunity to present their proposal and respond to the staff report. Then anybody else who wants to testify about this application, whether in support, in opposition, or with questions or concerns, can testify. Once everyone's had an initial opportunity to testify, I'll give staff and the applicant alone the opportunity to respond to the testimony that was offered. If those responses include any new evidence, I will give everyone a chance to respond to the new evidence. Otherwise, I'll close the public portion of the hearing and announce what I'm going to do. Generally, I will issue a written decision within about 2 weeks after the close of the record. I'll send my decision to the county. The county will send it to parties of record. So anybody who testifies orally or in writing before the close of the record will be sure and receive a copy of my decision when it's issued. Anyone with an interest in this application may offer relevant oral or written testimony, but testimony should be relevant to the applicable approval criteria, which are set out in the staff report. Also, please don't repeat testimony offered by yourself or earlier witnesses. Repeating your testimony doesn't make your case any stronger. The only issue before me is whether the application does or does not comply with the approval criteria. It's not a popularity contest. Whether everybody loves it or everybody hates it is not an issue I get to consider. However, it's important that all parties make their best case to me. My decisions are final for purposes of the county, but may be appealed to the Land Use Board of Appeals, or LUBA. However, LUBA generally will not allow new testimony and evidence on appeal. They'll decide any appeal based on the record before me. So if you feel it's important that myself or any future decision maker knows something about this application, you need to make sure it gets into the record before me. And in order to preserve your right to appeal, you or someone expressly representing you must testify orally or in writing before the close of the record. And in order to raise an issue on appeal, someone must have raised that issue before me with enough specificity that people can understand what the issue is. If the applicant wants to object to conditions of approval on constitutional grounds, they must raise those issues before me as well. If anyone feels they need more time to prepare, you can ask me to hold the record open or continue the hearing. If I hold the record open, you'll have an opportunity to submit additional written testimony and evidence before I make a decision. If I continue the hearing, we can come back and do this again at a later date. But whether or not the hearing is continued or the record held open for any other purpose, state law requires that I hold the record open for an additional week for the applicant alone to submit a final written argument without any new evidence. The applicant can waive that right if they choose, But if anybody else wants me to hold the record open or continue the hearing, you must make that request before the close of the hearing today. When you testify, please begin by stating your name and full mailing address. Please spell your last name so I get it right, although it looks like everybody's name is listed. Sometimes it's just initials or other things. If you represent someone else, please say so. And if you come back and testify again, please give us your name. Again, you don't need to give us your address, but just in case there's someone listening to this, they know who's speaking at a particular time. Staff will summarize the process for the technical issues with how to participate via Zoom, and that concludes my introduction. All right, Ms. Lord.
Great, thank you. This public hearing will be conducted virtually using the Zoom platform. Panelists for today's hearing, which include the hearings officer, county staff, and the applicant, have both audio and video capability. Audience members who have joined the meeting will have their microphones muted unless they wish to testify, in which case they will be called upon to do so by the county staff moderator. Audience members' video will not be turned on at any time. Today's hearing is being recorded as required by law. The county will make every effort to post this recording on our website later today. There is a designated time during the hearing when it will be open for testimony. The hearings officer will make it clear when this is. If you want to provide testimony, you will use the raise hand feature. For attendees on PC and iPad, you have a raise hand button on the Zoom bar, either at the top or bottom of your screen, depending on your device. When the moderator switches you over to provide testimony, your screen will look different for a little while. Primarily, you will see all participants' cameras, not just the one who's speaking. Staff will call upon you when it is time for you to provide your testimony. Be sure to provide your name and mailing address when you begin. Once you've provided your testimony, your microphone will be muted and your screen will be returned to normal. If the record is left open at the end of this hearing and you wish to submit additional written testimony, you can email that written testimony to myself at mlord@clackamas.us, or you can mail it to Clackamas County's Planning and Zoning Division at 150 Beaver Creek Road, Oregon City, 97045. My contact email address is also available on the webpage where you found the Zoom link for today's hearing. Testimony must be received by 4 p.m. on the day that the record closes. People who testify and provide their mailing address will receive a copy of the hearings officer's written decision. If you do not wish to testify but would like to receive a copy of that decision, you must provide your email or standard mailing address to myself by emailing it to me at mlord@clackamas.us or by entering it into the Zoom chat function during today's hearing.
Okay, you want to go ahead and proceed with your staff report?
I will, yes, thank you. So my name is Melissa Lard. I am the senior planner representing the county for land use file Z0161-24, which is a conditional use application. The subject property today is at the corner of Lucky Lane and Curran Road, which is just east of the city limits of Estacada. The property itself is just over 20 acres in size, and it's zoned zoned ag forest. The applicant is proposing to construct a municipal water storage reservoir. The reservoir will be green, bolted steel tank with an aluminum dome top. The applicant is requesting us to review two possible sizes or designs of this reservoir. In either case, the reservoir would still be the green bolted steel tank with aluminum dome top. Design option 1 is a 500,000 gallon reservoir that's about 60 feet in diameter and 28 feet tall. Option B, or design number 2, is a 1 million gallon reservoir that would be about 81 feet in diameter and about 30 feet tall. In either scenario, the proposed location of the reservoir would be in the northwest corner of the property, indicated by this red arrow here. Generally, I've provided a picture that was in the application materials of the elevation view or the profile view of the reservoir. In either case, the 500,000 gallon tank or the 1 million gallon tank, they'll look generally they'll look to be about this design, we'll say. So this is a conditional use permit in the ag forest zone. A reservoir or water impoundment is listed as a conditional use, subject to several review criteria. All of those review criteria are specified in my staff report, which was entered into the record as exhibit number 1. For the purposes of today's meeting, I'll only touch on just a few of the relevant review criteria rather than all of them. Ultimately, I'll note here that staff does recommend approval with conditions of this application, and I'll outline some of those reasons in the following slides. So with a conditional use permit, one of the criteria we have to look at is whether the subject property is suitable for the proposed use. And we can consider things like property size or shape, location, topography, things of this nature to determine whether or not the characteristics of the property are suitable. And in terms of this particular application, looking at the location, we know that it's important for the water reservoir to be near the service area of the water district. So this specific property is within proximity to their service area, which makes it suitable in terms of location. The topography and elevation of the site, the actual development area of the property is relatively flat. And so that makes it suitable for the construction of it. And when we look at the site elevation, it's important for the reservoir to be at an elevation that's higher than the service area, which this particular property is. Looking at natural features or environmental features, I think it's important to note here that there are no presence of regulated environmental features on the subject property. And what I mean by that is this property is not within the floodplain. It does not have any stream conservation areas that are regulated by our zoning code on the property. And it does not have any mass movement hazard areas that are regulated by our zoning code. And mass movement hazard areas, we talk about this in zoning code section 1003, and it references specifically the Bulletin 99 maps. These maps are issued by DOGAMI, which is the Department of Geology and Mineral Industries, which is a state department, and this particular property does not show mass movement hazard areas on the Bulletin 99 maps. And so in terms of regulated environmental features, section 1003 of our zoning code does not apply. However, there was a public comment that expressed concerns that we received, expressed concerns about shallow landslides nearby. And so looking into this further, I think when we are responding to this review criteria from section 1203 of just the suitability of the site, we can broaden our horizons of the areas that we look at for information. So looking at the Slido maps, which is a statewide landslide information database of Oregon, Slido. Looking at the Slido maps, there does show that there's a risk of perhaps shallow landslides in the area. And so because of this, staff has recommended a condition of approval, which is condition number 5, that an engineering geologic study be required to be submitted in order to meet this particular zoning criteria. I will note here that as an advisory note, I also included in my staff report that the building department, to meet the building code standard, will require a geotech report. And so this requirement, likely, if not a zoning requirement, will still be a requirement of our building code review when it comes time for actually permitting the structure. Next, we look at whether the proposed use is going to alter the character of the surrounding area in a way that would substantially limit, impair, or preclude the use of surrounding properties. Surrounding properties here are also zoned ag forest. Predominantly, uses that are primarily allowed are generally farm and forestry uses. There are others, but that's the largest list of uses that are primary uses in the zone. The water reservoir would not produce any noise, light, glare, or odor. So for these reasons, I think that the use would not impact the character of the surrounding area substantially. Similarly, in terms of traffic, when we look at vehicle traffic that might be generated from this project, it's an unstaffed facility. It would be visited minimally or infrequently just for maintenance or the occasional servicing needs to visit that. And so between these potential impacts of the water reservoir, we found that they would not substantially limit or preclude the use of surrounding properties. The applicant, in terms of surface water management, the applicant did provide a preliminary statement of feasibility from the Clackamas County Engineering Division, which confirms that stormwater management here is possible to meet all of our standards. The Engineering Division recommended a condition of approval, number 13, to require a stormwater management plan if the project would have more than 10,000 square feet of new impervious surface. That's not the plan, but I think as a just in case type of condition, the engineering department added that in to ensure that the applicant knows if we do exceed that limit, that the stormwater management plan would be required. I will note here that there's perhaps not a typo, but a few words in that condition that were omitted that might benefit from a couple extra words added in there to make some more sense. So as it reads currently, the condition says a stormwater management plan, roadway standards, chapter 4, etc. I'm recommending here an updated condition if you do choose to adopt this condition to read more along the lines of a stormwater management plan in compliance with roadway standards, chapter 4, etc. Just for some clarification on the verbiage there.
Appreciate that.
In terms of ZDO section 1007, which looks at roads and connectivity, again, our engineering division of the county looked at this application and determined that the roadway is suitable to support this use. There is a condition of approval requiring that there's at least a minimum 12-foot width along Lucky Lane extending from Curran Road to the subject property or to that development site. It looks like the width of that Lucky Lane varies somewhere between 12 and 15 feet approximately. So there's a recommended condition of approval just to verify that there is in fact at least 12 feet of width of that gravel on Lucky Lane. ZDO section 406 applies. What we have to look at here is that the proposed use will not force a significant change or increase the cost of farming or forest practices, and that it will not significantly increase fire hazard or fire suppression costs. When looking at the subject property, we see that it is currently in farm use, with the exception of this cutout for the water reservoir. The property will continue to be in farm use. There's no, as I mentioned earlier, no noise, light, smell, glare that might impact surrounding farming or forestry practices in the area. And there would be limited traffic added to the roadway, so there wouldn't be any impacts to farming or forestry operations in those senses either. Fuel-free brakes, which we'll talk about momentarily, are required. And the steel tank itself that's proposed is likely to not be flammable, certainly not as perhaps a wooden structure, for example, might be. Lastly, we looked at the location of the proposed reservoir in context with the whole property. The reservoir being sited right up against the road means that there's no need for additional roadways to be added onto this site to access this particular structure, and really allows the fire department, if necessary, to access this structure using the existing roadway, which can help with fire suppression costs and then their safety to the fire personnel. So for those reasons, we found that the standard was being met. Fuel-free brake standards, we determined do apply. The standard is establishes that any new structure that's approved with a land use application after April 28th, 1992 must meet the fire siting standards. ZDO section 202 is our definitions section. We define structure as anything constructed or erected which requires location on the ground or attached to something having a location on the ground. So by definition, the water reservoir is in fact a structure. And so we do need to apply the fuel-free brake standards in the zoning code. The primary fuel break area is a 30-foot buffer around the proposed reservoir. This 30-foot buffer is established. There's a table in our zoning code that references, based on the slope of the property, how far your buffer has to be. Because the development site is generally quite flat, the requirement here would be a 30-foot buffer. The inside of this primary fuel-free break area, or this 30-foot buffer area, there are limitations specifically to vegetation height, vegetation density, and that it states that that area must be maintained in perpetuity. So we always need to be ensuring that this area surrounding the structure is being cleared as described in our zoning code. I've got a couple of pictures here. These are snippets from the submitted plans that the applicant submitted. The blue rectangle here is a picture of the easement area. So the applicant secured an easement from the property owner for the location of this reservoir. And in the 500,000 gallon reservoir design option, we can see I've added these green circles or green ovals here to show that there's the 30-foot buffer is being met entirely within this easement area. And so there's a 30-foot setback on all sides to the edge of the easement area. And this I'll talk about in a moment, but I think it's important to note that in the smaller design, all of the fire fuel-free break area could be maintained within the easement area. Alternatively, we've got the 1 million gallon reservoir, and you can see I've added some red ovals, and not all of that fuel-free break area would be maintained within the easement area in this larger design. And so when considering our zoning code, there's nothing that states that the fuel-free break area has to be within the easement area. It's not what I'm suggesting. However, I think that in terms of maintaining and enforcing the maintenance of this fuel-free break area, it would be important for us to establish a maintenance agreement between the property owner and the applicant here, or vice versa, and determining who's responsible for maintaining that primary fuel-free break area. So in the 60-foot diameter tank scenario, or that 500,000 gallon tank scenario, all of that fuel-free break area would fit nicely within the easement they've already secured. However, in the larger tank option, the 81-foot diameter tank, some of that fuel break area would be outside of the easement. And so I think that in terms of logistics, it would be very hard to ensure enforcement of two separate areas that are managed by different people. And so for those reasons, we've recommended condition of approval number 6 to have some type of maintenance agreement for the entire fuel-free break area. This could also look like perhaps the city, if they were able to get a larger easement area and include that fuel break in there, we'd consider that as well. But again, not requiring a larger easement area. I just think that some type of maintenance agreement to establish clearly who's responsible for this area would be most beneficial to the applicant, to the property owner, and certainly to the county from an enforcement standpoint. So for these reasons and all of the other reasons I've listed in our staff report, staff does recommend approval of the land use application subject to some conditions. And with that, I will stop sharing my screen and answer any questions if you have any.
Okay, I don't have any questions at this point. Thank you.
Okay, thank you.
Who's going to appear on behalf of the applicant first?
I guess I would like to. I'm Peter Watson, the city attorney for the city of Estacada. And obviously we're here to talk about conditions and the wildland urban interface. Originally, the bill that established the statute was Senate Bill 360. It was passed in 1997. The legislative purpose of this was twofold. One, it was recognizing that firefighters that were protecting dwellings needed room around the dwellings in order to fight those fires. The second purpose was that those dwellings and certain other structures added fuel to the fire, and that would make the fire worse. So one, how do we protect these homes and ancillary structures? And secondly, how can we prevent them from adding fuel to the fire? The statute that Senate Bill 360 became is ORS 477.027, and the implementing administrative rules are OAR 629-044-1005. And what's interesting about those OARs is that their definition of structure is different from the county's definition of structure. So the definition of structure for that OAR, which is found in OAR 629-044-1005G, is any building that is at least 400 feet. So the reason for that
400 square feet or
400 square feet.
Okay.
The structure.
Yeah.
So what the reason for that is because, as I understand the legislative history, and different square footage numbers were used at different points. At one point, it was 500 square feet. Is that if a building is under a certain square footage, it's not adding sufficient fuel to a fire to make the fire worse. So what we have is a metal water reservoir. I do not believe that it is a structure under the OAR. Rather, it is under OAR 629-044-1005F, and other human development. And within that definition of other human development is essential facilities. And this water tank is an essential facility in order to make sure that the city has sufficient pressure in our system in order to fight fires. And that's not a theoretical issue for us. That's a very real issue. Several years ago, when the town was under the major threat of wildfire, it seemed like it might burn. People were watering their roofs to try and protect their houses. And that made it so that our firefighters didn't have the pressure that they needed in these other areas to do their job. And so by adding this reservoir, we're adding redundancy to our system and pressure to our system. Again, looking at the legislative history of Senate Bill 360, there were the two purposes. One was so that firefighters would have adequate opportunity to protect certain structures that are listed. In this, the firefighters don't need to protect the water reservoir because the water reservoir itself is not flammable. In fact, the firefighters would utilize this water reservoir in order to protect other structures and to charge their tenders and other equipment with water. So this structure actually, A, can't burn, B, can't add fuel to the fire, and B, is necessary for us to fight fires sufficiently. So in my opinion, it's clearly not within the definition of structure as established by this statute. In addition to that, there were very limited properties that met all the requirements for us to locate this reservoir. There were essentially only 3. There were others that might have been used, but it would have required us to acquire other right-of-way from other property owners. So essentially, those were not feasible. One of those sites that was feasible was a cemetery, and the portion of the cemetery that we would have located the tank at is where
Cemetery on Curran?
Yeah.
Okay.
Is just down the road.
Yeah.
It's where people park. And so they were like, if you literally can't find anywhere else, we can have another conversation, but we can't meet our duties as a cemetery board well if we're selling you this land, because people attending funerals or visiting loved ones that had passed would have to park on the street. It would have really limited their parking. So that wasn't one that we wanted. The other one, besides this location, we simply could not get the owner to engage with us. And then when we finally did, she said, well, you can buy all 9 of my acres or nothing. So again, that wasn't a great outcome. We paid substantially more than appraisal for this property because of our lack of options. The property owner now has complete leverage. So we either would need to spend money that we don't have, or we would need to do the 500,000 gallon water tank. And either of those outcomes for the city are really bad outcomes. So again, I think based off of the OAR 629-044-1005F, that this is a essential facility. It is not a structure. And again, the state's own definition of structure is any building that is at least 400 feet. And so the county's code simply isn't consistent with the state OARs because A, they don't have a carve out for essential facilities that could be used to fight fires. And B, it would apply to a flagpole. Like it would apply to anything that is a structure. And much like our tank, a flagpole isn't going to burn or add fuel to a fire during a wildfire. So
is this 1 million gallon reservoir greater than 400 square feet or less than 400 square feet?
No, it's greater than 400 square feet, but it's an essential facility. So
okay, so I was wondering how that square footage thing came in.
It would fit under the F definition of other human development,
right?
And part of other human development is essential facilities. So
yeah, I understand that
structure at all. I merely bring up the structure in order to illustrate the difference between the state's definition of structure and the county's definition of structure.
Okay, that's what I wanted to make sure I understood where you're going with that.
Structure was to meet those that legislative intent. So if something is only 20 square feet, then because it's not really adding fuel to a fire, even if it is flammable, then it wouldn't fit under that definition of structure. So, and I think the other reason is because in other areas, structure is anything man-built. And in this statute's very specifically trying to protect certain properties that are built at a certain density on that wildland urban interface. And so kind of the definitions for that as compared to other areas where any government might want to regulate any structure are different. So that's why we would prefer that we not have to meet that condition of 30 feet, because again, our only way, this property is not within the city. It's not like we could enforce against the property owner to maintain that clearance unless we had a separate negotiated agreement with him or acquired more right of way. At this point, the owner has all of the leverage because our city council has made it clear during public meetings that they don't use eminent domain. So we basically would have, unless they revisit that decision, we would have to pay whatever the property owner wants, or we would have to go with the smaller storage tank, which does the opposite of what we're trying to do. It creates less redundancy of the system, less pressure. We're less able to use it in the event of a wildfire. So those are the reasons that we would ask that we would appeal that condition to you, and that we would ask that condition is not imposed.
Okay. Thank you, Mr. Watts. Is that it from the applicant at this point?
Yeah, I don't know if Kurt, our city engineer, has anything to add.
No, I think everything's presented fine. I don't have any concerns.
Okay, thank you. Is there anybody else who'd like to say anything about this application? Please click on the raise your hand button now so we know you'd like to testify. Alice Zabitsky, I hope I'm pronouncing that right. You'll need to unmute yourself, it looks like. There you go.
Okay, I just have a few questions.
Can I get your name and address first, please?
Oh, Alice Zabitsky,
Thank you.
31701 Southeast Curran Road, Estacada.
Okay.
Anything else?
Nope.
Okay.
I
just have a question. Where is the water coming from that's going to fill this reservoir?
Good question. I will ask the applicant to respond.
This is
City engineer.
Yeah, this is Kurt McLeod with Curran McLeod Engineers. We're the engineer for the city of Estacada. Have been since the middle 1980s. All of the waters for the city of Estacada comes from the Clackamas River. We have water rights for 2.6 million gallons a day to be taken from the Clackamas River.
And how does it get to this? Does it or will it get to the site? Where's your pipe going to go?
The water is treated adjacent to the Clackamas River, and then it's pumped into the low-level systems, and then sequentially it's pumped into the high-level system. So distribution pipe is on Woodland Road that will get water up to Lawrence, and this reservoir is the extension. Lucky Lane is actually the extension of Woodland Road. So the water would come from Woodland Road and extend past Lawrence to the reservoir site.
So
there's an existing pipe in Woodland and you'll just extend it down Lucky to the site?
Yes, I should have explained that. We have an existing pipeline with Woodland, and that pipe continues north on Lawrence.
Well, how's it going?
Okay, good.
How's it? Excuse me. How is it going to get to the reservoir from Lawrence? Do you have existing piping, or are you going to have to install something?
No, we need to build about 2,000 feet of pipe to go from Lawrence to the reservoir site, which would all be in an existing county public right-of-way.
Okay. I guess that was my main question, is how the water is going to get in there and where it's coming from.
Okay.
You got it.
Thank you, ma'am.
Thank you.
I'm just finishing up my note here, but if anybody else, Ms. Zabudsky, if you'd click on the raise your hand button so we know you've testified, and if anybody else wants to say anything, please click on the raise your hand button. I am not seeing anybody else. Anything further from county staff?
Sure. In response to Mr. Watts's comments earlier, I think the wildland urban interface was the particular section that you were referencing. And I think in the context of the adoption of the statewide wildfire risk maps, the OAR 629044 section that you had referenced isn't, I guess I wouldn't describe it as in effect when we think about it in context of the statewide wildfire mapping. The draft map is out for review right now, which would designate the wildland urban interface and then 3 classes of the wildfire risk. But it's my understanding that areas outside of both high risk and the wildland urban interface would be subject to that defensible space standard from the state fire marshal, and then fire hardening requirements through the building codes, which I think is similar, but I think separate. So I don't necessarily agree that the particular OAR section that you're referencing would be applicable in this case, but nonetheless, the primary fuel break zone requirement that the county has in our zoning code comes from a different OAR standard, OAR 660-006-0035, which does in fact say that the owner of dwellings and structures shall maintain a primary fuel-free break area surrounding structures, but it includes both dwellings and structures. I don't believe that OAR 660-006 section defines structure, but nonetheless, our zoning code does. And so I think that our zoning code standards for primary fuel-free break areas come from a different section than the one that you're referring to. So in that sense, I would say that our zoning code is consistent with the OAR.
Thank you,
That's
Ms. Lloyd.
Thank you.
Just to make sure I understand what you just said, there's this, get my numbers straight. The OAR, the applicant cited 629044. You don't, that's the statewide study that I've been hearing about, and you don't think that's in effect yet. But regardless, even if it is in effect, the 660-06035 that you cited is the basis for the county code. And so the one the applicant cited doesn't apply here. That one does, the 660 does.
I would agree with that. Certainly the second half of that relates to the 660 component. My understanding of the 629 is lesser than the 660, but it is my understanding that OAR 629 section is, as it relates to the wildland urban interface, specifically relates to the statewide wildfire risk maps that have not yet been finalized.
Okay, thank you.
Can I ask a question?
Yes, absolutely.
Because Clackamas.
Can I get your name and address?
Sorry, Elena Turpin. I'm the Assistant City Manager for the City of Estacada.
Go
Do you
ahead.
need the address?
I don't, just county staff.
Okay, great.
Okay, you're the applicant, so you're okay.
Yes.
You're
yes.
the assistant city manager, is that your title?
Yes, correct.
Thank you.
So the county has adopted their own wildfire risk mapping where they outline the interface itself. And would that not apply regardless of whether the state map has been adopted or not? Because the county has accepted their Clackamas County Wildfire Protection Plan, which does adopt their own mapping.
Did you mean to say the state has accepted the county's maps? You said the county has adopted the county.
The county has adopted their own maps.
Okay, their own, okay.
Yes.
Just want to make sure I understood what you just said.
Yeah.
Yeah, I'll let the parties make that argument. Thank you, ma'am. Ms. Lord, can you respond to that?
I am not so familiar with wildfire maps that have been adopted by the Board of County Commissioners, so I can certainly look at that and then follow up.
Okay. It's my assumption that the wildfire maps are under the 629, whereas this standard, the county site is under 660 of the OARs. And so the county's argument that 660 authorizes the county's fuel break standard would apply. I'm not ruling on that in any way. That's my understanding of the county's argument. So I'll consider that, and I'm going to look at all these OARs and ORS in detail. Mr. Watts or any other representative of the applicant?
Yeah, so I recognize that the state is going through that mapping process right now, that the fire marshal is going through that, and they don't yet have the adopted maps. But this statute and these OARs long predate that. It's from 1997. And what they found when they started implementing this, and again, this is as I understand it, and I've done a pretty deep dive into both the legislative history and also the issues that were associated with this program, is that certain counties adopted maps and had those maps acknowledged, and other counties did not. And the counties that did tended to be more urban counties, and the counties that did not tended to be more rural counties, particularly in Eastern Oregon. And there was essentially no mechanism in order to force that to occur, and there essentially was no mechanism to fund future mapping. And so I believe it was 2 years ago, I don't have that bill in front of me, but 2 years ago they switched some of the authority over to the fire marshal or the state forestry, and they're now doing this mapping. But the kind of the reason for that is because not for the counties that are already mapped this urban-rural interface like Clackamas County, but rather for the counties that had not. And then again, going back to the legislative purpose of this, it's to help defend fires and to prevent structures from fueling fires.
Mhm.
Ending up with a 500,000 gallon tank instead of a 1 million gallon tank is really contrary to the whole purpose of the statutory scheme. And I get that the county has the definitions that they have, and I absolutely believe the county's working on this in good faith. It's just that their standards aren't consistent with the state OARs, and we default to the state OARs to the extent that the state defines structure differently for this purpose as compared to other purposes. That's the default. And if in the other section 035 they don't define it, well, in this one they do, and this is the state. These are the administrative rules that were established by the state to comply with the legislative ORS 477.027.
Okay. Just a thought that I'm going to throw out that occurred to me as we were talking about this issue is, if, again, I am not ruling on anything, if I happen to agree with the county that their standard applies, but a variance might be another option because you've got, it seems to meet the variance criteria. You've got an existing site, your lease site that you own, you've got a metal structure, so it's less of an issue. So even if the fuel break did apply, that might be a cheaper option. I don't know. Hopefully we won't get there. I'm going to consider this issue and go from there, but just a thought. The applicant has the right to have me hold the record open, so you can submit a final written argument if you want to expand on this OAR ORS fuel break standard. You can, or you can waive that, and I'll close the record today.
Well,
If you want to take a moment to discuss with your team.
Yeah, I feel like maybe I should confer with.
Yeah, absolutely. You can do it online or on the Zoom, or you can give them a call and we'll
walk out of the city manager's office and walk into the assistant city manager's office.
Yeah, we could take a 5-minute break or so. Does that work for you?
That would be, thank you very much.
Absolutely. I'll just stay here. Anybody, we'll be back in 5 minutes or so. Yeah, happy to facilitate this. I just before you, yeah, that's what I was waiting for, was a recording.
Okay.
to start. Go ahead.
So, but just, I'm not going to ask to submit supplemental briefing, but I would like
Okay.
to one more point, which is that Clackamas County, in there, it's titled Clackamas County CWPP fire agencies. It's a collaboration among the Community Wildfire Protection Plan. And it was adopted on March 14th, it's dated both March 14th, 2024, as well as it looks like the county commissioners adopted it on 6/27/24. On page 113 of that plan, as far as which is Estacada specific, under the local communities at risk strategic planning areas, the following is listed as the fourth factor: lack of water available for wildland firefighting. So the county itself in June of this year has recognized that the lack of water available for wildland firefighting is a major issue in Estacada specific. And so again, ending up with a tank that's half the size of what we could do is really contrary to Clackamas County's own stated risk factors.
Okay. Can you, I don't need to hold the record open. You referenced it. Can you send me a link to that document through
Yeah.
the county? That's great. Then I don't have to track it down on the internet.
Great, thank you.
Okay. Then with that, I'm going to, Ms. Lord, you had something you wanted to add in response to my variance
Yes,
issue.
thank you. You had suggested perhaps the applicant might look into a variance, and I just wanted to mention section 1205 of our zoning and development ordinance, subsection 120501D says that the fuel-free brake standards of section 406.08 you cannot get a variance to those standards. So a variance to those fuel-free brake standards is prohibited. So I
Okay.
just wanted to make that reference.
Thanks. And like I said, I just threw that out. If it comes to that, it's not allowed, so never mind. Mr. Watts, I want to give you the final word just in case you wanted to respond to that in any way.
No, just I think
Yeah.
we have the opportunity to keep the community safe and to stay within our existing budget. And you know, I think that we've demonstrated a path through statutes, through legislative history, and through state law that would provide us with that path in order to get to the outcome that benefits the city, benefits wildland areas that could burn outside of the city, and benefits our water users by adding redundancy and pressure to the system. And I would hope that we could, I hope we could go down that path.
Okay, thank you. With that, I'm going to close the hearing and close the record. I'm going to take this under advisement. I'm going to consider all the arguments I heard today and read some OARs and see where I end up with this. I totally understand the city's concern, the need for this water, the firefighting capacity, that this thing's not going to burn, but I have to apply the county's and state law, existing county law and state law. So I'll have to determine, putting those concerns aside, I have to determine what the code and the OARs and statutes say, and how I think that they come down on this issue. So whether it is subject to those fuel breaks or not is what I'm going to have to decide. So I'll do that. I will issue my decision. I'll try and get it out within 2 weeks, and I will send it to the county. The county will send it to parties of record. But that concludes our hearing. Thank you. Everybody have a good afternoon.